Okay, all right. Good morning, good afternoon, good evening. Welcome everybody to this third webinar of this series on international biodiversity law post-2020, which is part of the 17th course on multilateral environmental agreements, organized by the University of Eastern Finland's Center for Climate Change, Energy and Environmental Law, and the United Nations Environment Programme. My name is Patrick Toussaint. I am wearing two hats today. I am both a PhD candidate at the University of Eastern Finland, focusing on international climate change law. And I'm also an associate expert at the Secretariat of the Convention on Biological Biodiversity based in Montreal. I'm also here just as an interested listener, much like yourselves, and I'm very delighted to moderate this session since human rights and biodiversity are two topics that are very close to my heart. And today's webinar will be on synergies between international biodiversity law and international human rights law. Our speaker today is the excellent Professor Elisa Morgera. Elisa is a professor of global environmental law at Strathclyde University based in Glasgow. And she is a member of the Strathclyde Center for Environmental Law and Governance. Her research specializes in international biodiversity law and the rights of Indigenous peoples and small-scale fishing communities. She's also done extensive research on the right to science and the responsibility of businesses to protect human rights. Elisa is also the director of the One Ocean Hub, an interdisciplinary research collaboration across the UK, Africa, the South Pacific, and the Caribbean, pioneering research on human rights and marine biodiversity to support fair and inclusive decision-making. Now, before I pass the word over to Elisa, just a few housekeeping rules. The session will be roughly 1 hour. It is being recorded and will be made available on YouTube. And after Elisa finishes her presentation, we're going to open the floor to your questions and answers. If you wish to ask a question, kindly just type it into the chat box. There you can also upvote questions that you find interesting, questions asked by others, and we will try to make sure that we can address most, if not all, your questions. That's all for me. So without further ado, Elisa, you have the floor.
Thank you so much. And it's really a pleasure to addressing this topic with the participants today. There have been quite a few interesting developments, and in fact, they continue to happen quite intensely over the last 5 years in these areas of synergies between international biodiversity law and international human rights law. Is quite complex from a legal and policy perspective, and yet provides a lot of opportunities for thinking, I think, about the transformative change we need to really do better in terms of preventing biodiversity loss, ensuring biodiversity conservation and sustainable use. So we'll start by looking at some impressions about where we are at with the synergies between international biodiversity law and international human rights law, and then really go into some of the legal technicalities of this topic, but then we'll take some time to go through examples and really see the various facets of this synergy between international human rights law and international biodiversity law. So you're all very familiar with the findings of the Global Assessment on Biodiversity and Ecosystem Services, and how we have now, I think, a much clearer understanding of how what we understand as development, sustainable development, is dependent on biodiversity, and staggering how more than 80% of the targets of the Sustainable Development Goals have been documented as being reliant on healthy biodiversity and ecosystems. That said, we're still not necessarily fully developed in terms of the scientific basis and understanding the thresholds and tipping points in understanding the relationship between biodiversity and human well-being. And so we have, on the one hand, a sense of how much human well-being depends on biodiversity, but we're not yet at a point where, also from a legal perspective, we have a full understanding of the limits to our interactions with nature that can prevent a negative human rights impacts. And in fact, we don't have sufficient research and data to really clarify exactly how our interventions in terms of conservation and sustainable use contribute to human rights. So that understanding in terms of the data is still evolving. But we clearly see, I think we've got to a stage where we clearly no longer see nature in opposition to economic and sociocultural development. We understand how there are important interdependencies there, but we still tend to discuss the socioeconomic and cultural impacts of biodiversity loss and degradation, not necessarily in human rights terms. And this might partly be because within the Convention on Biological Diversity, we often speak of issues that are recognized as international human rights issues without engaging necessarily with that terminology. And CBD parties have different views around how international biodiversity law interacts with international human rights law, which parts of international human rights law are applicable to biodiversity and biodiversity national action, as well as international cooperation. But that said, there is an understanding, and we will go into details to see how issues related to human rights have been addressed in different ways under the convention, and in fact have been recognized externally, including by international human rights bodies, for instance, the Inter-American Court of Human Rights, as being really important contributions to the understanding of international human rights law. And this has been particularly the case of Indigenous peoples and local communities, but not exclusively the case. And partly we may reflect on whether these advancements in the context of the CBD are due to the degree and the ways in which Indigenous peoples and local communities representatives participate in CBD negotiations, as opposed to maybe other MEA negotiations. And also whether this capacity to discuss and develop consensus language by the Conference of the Parties of the CBD has maybe more leeway to experiment because of the lack of a compliance mechanism under the convention, and whether or not the lack of the compliance mechanism has also created certain limitations in how much the CBD has affected or monitored state practice and international cooperation in this area. So these are all live questions that I think will be interesting to explore with you today. And of course, there are examples in which certain CBD decisions have really clearly shown the different divergence of views of CBD parties as to how they wish to engage with international human rights law, the degree to which they wish to use international human rights law language, and engage in an evolving interpretation of the convention in light of other international human rights instruments. And so in this particular case, eventually in 2014, parties agreed to use the term Indigenous peoples and local communities in COP decisions, even if the convention itself referred to Indigenous and local communities. And you can see how in the text of the decision, there are specific cautions around the extent to which this change in terminology affects or represents an agreed understanding of the official interpretation of the convention and future COP decisions. So we will not go into the details of this, but just I think to convey to you that this matter of the relationship between international biodiversity law and international human rights law is quite complex from a legal perspective and engages very much questions related to treaty interpretation and interpretation of international law, but it also has some political dimensions and policy dimensions, and different countries see this relationship in different terms based also on their own constitutional traditions and approaches to human rights. That said, so this is the image from within the CBD, but it's also interesting to see how the CBD is seen from the outside, in the outside world. And so I've just provided here a few quotations from one decisions of the Inter-American Court of Human Rights, where I've seen the most engagement with the CBD treaty in itself, its articles, but also CBD COP decisions, and how particularly I think on the basis of the expert opinion that was provided by the former UN Special Rapporteur on Indigenous Peoples, Victoria Talley-Corpuz, there was this understanding of how the Conference of the Parties of the CBD have developed interpretations of the convention that are aligned with the international protection of Indigenous people's rights, and in fact can contribute and enrich the interpretation of relevant international human rights law in other fora, such as the Inter-American Court itself. And we can see that, for example, on the basis of CBD instruments, including certain decisions, the court, for instance, was able to identify specific criteria to ensure that the creation of protected areas respects the human rights of indigenous peoples. And so including effective participation, the possibility to continue to have access to traditional territories, and fair and equitable sharing of benefits arising from conservation. So that's one interesting, in a way, positive assessment of the synergies, actual and potential, between human rights and biodiversity law. On the other hand, other international human rights bodies have expressed also concern. There may be this understanding of the importance of how international biodiversity law and human rights should work hand in hand, might not be sufficiently understood or reflected within the CBD itself. And so, for instance, quite recently, the Special Rapporteur on Human Rights and the Environment, David Boyd, cautioned against the kind of more traditional approach to biodiversity conservation, and calling upon all those involved in conservation efforts to move towards a human rights-based approach to conservation, moving away from what is now termed fortress conservation, which has led in the past, but also in the recent past, to, for instance, forced displacement of indigenous peoples and other groups, and has also led to other human rights negative implications, towards a human rights-based approach, which is seen as part and parcel of that transformation, that transformative approach that both the IPBES and the IPCC have been calling for us to really make progress in terms of global biodiversity targets and climate change targets. And so what all these elements that I'm offering at the start of this lecture aim to show is that we are looking at an evolving picture, a picture where on the one hand, we have had important developments and rapprochement and mutual influence between international biodiversity law and international human rights law, sometimes outside of the CBD framework. And yet we also have growing expectations that that engagement with international human rights law might become more explicit and maybe more ambitious and systemic even in the context of the Convention on Biological Diversity. And this is quite relevant and has become really visible in the context of the ongoing negotiations of a post-2020 global biodiversity framework. Now, one of the questions that we may ask ourselves before we go into example is, why does this matter? Why are these synergies important for us to understand and discuss, both as a matter of international law, but equally as a matter of the national implementation and understanding of international cooperation? And I think from my perspective, there are two important aspects to these synergies. From a legal perspective, there are often discussions both in the academia, but also in CBD negotiations about the content of the obligations that are included in the Convention on Biological Diversity. And we know that the treaty itself has used open-ended language and offers a wide degree of discretion for different states based also on their particular ecological conditions and approaches, but also their own socioeconomic conditions, to really have a targeted approach and a context-specific approach to the implementation of their international biodiversity obligations. Now, this discretion is really important, but at the same time, it does create doubts as to what is the minimum content of these obligations and where really a party, a CBD party, may be lagging behind in implementing its obligations under the CBD. So once we read CBD obligations in light of international human rights law, and we really wonder and assess to what extent not fully implementing the CBD may lead to negative impacts on human rights, this is where I think we are able to identify a minimum content of state obligations under the CBD, and clarify also necessary procedural guarantees. They may have to do with access to information. They may have to do with specific guarantees that need to be included in national law, for instance, and they may in turn allow for access to courts and effective remedies. And once again, we know that the language usually used in CBD COP decisions, but also say in the Nagoya Protocol, is often a bit more open-ended in terms of whether states need to adopt legislation as opposed to administrative or policy approaches. But once we bring international human rights law to bear on these matters, we see that in some cases where human rights obligations may be at stake, then, for instance, we need countries to develop laws with all the guarantees that laws bring with them to ensure a certain level of implementation. On the other hand, I think it's really important to see what are the benefits to international human rights law that derive from those synergies. And I think particularly when we get to the nitty-gritty of the difficult decisions for governments from the central to the local level on how to conserve and sustainably use biodiversity, you really need to have the insider knowledge of how natural resource governance works to really find the hooks for ensuring an ecosystem approach, but also a human rights-based approach. And so all the action and all the decisions that have been adopted by the Convention on Biological Diversity by its parties provide that really fine-grained, technical, and very practical understanding of how and where we can put human rights standards in practice in the context of environmental governance and management. So while not using necessarily human rights language, they really give very detailed and helpful guidance to managers, to decision makers, also to conservation organizations and business on how to take into account human rights issues, even if they're not called as such, in pursuing biodiversity conservation and sustainable use, to a level of detail that escapes international human rights bodies, even if, like in the case of the Inter-American Court of Human Rights, they do engage and have very clear expectations about how states should conduct themselves in creating protected areas or, for instance, licensing logging activities or mining activities. But there's also a practical perspective, which I think is really important, and is that we can bring together international human rights constituencies and biodiversity constituencies and really see a shared agenda for global action, a shared priority where we can tap on the diverse capacities and understanding and networks of human rights and biodiversity experts, where we can come up with maybe more imaginative or yet untested approaches in the biodiversity sphere, and build new alliances across sectors to really push forward and improve our efforts in conserving and using sustainably biodiversity. So I think that that's quite an important area of potential transformative approaches, but we have to be mindful, I think, that at this stage, we're still building bridges between the human rights experts and the biodiversity experts to understand each other and their respective approaches, and then to find shared approaches that can be mutually beneficial. A lot of work in this direction in building bridges has been done by the former UN Special Rapporteur on Human Rights and the Environment, Professor John Knox, whose 2017 report on biodiversity, I think, provided the first very clear international discussion of the degree to which international biodiversity law matters from an international human rights law perspective. And other than this matter of principle, but thinking about how in biodiversity terms, we often talk about human well-being, but we don't necessarily really then break that down in terms of relevant and internationally protected human rights. We may talk about discrimination, but we don't necessarily then think about the implications that are much clearer in international human rights law terms. But I think even more interestingly, what that report did was really clarifying how we operationalize this understanding of interdependencies of international biodiversity law and international human rights law. And what Professor Knox did was really boiling it down to saying, well, when we come to decisions about biodiversity, we need to seek a reasonable balance between protecting biodiversity and other legitimate societal goals, which also means understanding when biodiversity protection is actually a way to protect other societal goals, such as, say, human health or children's human rights. And what we need to do in our decisions is avoid unjustified and foreseeable infringements of human rights that may be dependent on biodiversity. And this has both to do with public interventions, but also potentially private sector interventions, not only in areas where we know that human rights violations may occur, such as extractives, such as mining and logging, but also in the creation of protected areas, in the setting up of climate change response measures, or in the development of renewables. And so here, what's really asked of governments and all the actors within states that are responsible for biodiversity is to really try and understand and take into account those interdependencies, where our decisions on biodiversity may have human rights implications which we may not be aware of, and really being as systematic as possible to understand which groups in society would be negatively affected by decisions that, for instance, allow for certain uses, including potentially unsustainable uses of biodiversity, as well as fully understanding the benefits and who may be negatively affected by the creation of conservation measures. And this has to do both with action at the national level, but also international cooperation, including, for instance, biodiversity financing, but also climate change financing and capacity building. And so that has really important implications, both from a procedural perspective, how we need to make decisions about biodiversity transparent, participatory, and also with potential access, actual access to justice and effective remedies, and how we need to take into account also particular situations of those human rights holders that may be most vulnerable to certain decisions on biodiversity, including, for instance, children. And looking at biodiversity defenders as human rights defenders, because of that, the importance of biodiversity conservation and sustainable use for a whole series of very basic human rights that may be right to health, to life, to food, or to water. So this has been a bit of a general introduction, and now I'll give a few practical examples just to get a sense of how this understanding of the interactions between human rights and biodiversity has already been captured under the Convention on Biological Diversity, and where we have initial, maybe further interactions between these bodies of international law. Many of you may be familiar that if we look at the text of the convention itself, the CBD, there are two key articles that speaks to the issues of indigenous peoples and local communities, Article 8J on traditional knowledge and Article 10C on customary sustainable use. And those two articles, even if they have been criticized, for instance, for being quite open-ended and with qualified language, have been really engine for transformation in terms of how they have been then applied and understood in the context of a variety of CBD COP decisions, including the whole set of work that the convention has done on the ecosystem approach, and very much including as part of the ecosystem approach, the consideration, the recognition, and the protection, both of the traditional knowledge and the other contributions of indigenous peoples and local communities. And on the basis of all this body of decisions that have been adopted under the convention and how they've been understood in international human rights bodies, we find now, let's say, today's picture of what international law at the crossroads of human rights and biodiversity say, in as far as indigenous peoples and other communities are concerned. And this is UN Framework Principle 15 of the 2018 UN Framework Principles on Human Rights and the Environment. And we see how maybe slightly drawing on the language of the CBD, but very much drawing on the further clarifications that have been developed by the Conference of the Parties, we have now a series of safeguards to make sure that in decisions around biodiversity and the environment, but also any other decisions that may affect biodiversity, we also take into account systematically any potential negative impact on the human rights of indigenous peoples. And this, in a way, in a nutshell, boils down to three key safeguards: environmental and sociocultural impact assessments, free prior informed consent, and in some countries, maybe different terminologies around the concept of consultation, and fair and equitable benefit sharing. And what's interesting here is that these are three standards that really have become widely accepted across different bodies, including regional human rights bodies, but they have drawn in their understanding of how they actually work from CBD work, particularly the CBD Aquacon guidelines have been referred time and again by international human rights bodies to give a much clearer sense of what is required from states in both respecting CBD obligations on biodiversity and respecting relevant international human rights law obligations. There are, of course, a lot of complexities around these safeguards. There's a lot of evidence that when they haven't worked, and there's a lot of learning about how to make them work better. And again, really understanding how the CBD guidance and international human rights standards can work together gives a much clearer understanding of how these safeguards should be put in place and how we can avoid negative impacts on human rights, while we need to remain very alert that practices on the ground are generally falling behind expectations. Again, from an international law perspective, it's also quite interesting how the guidance provided under the CBD has been picked up by other international human rights bodies in respect to business responsibility to respect human rights. So often CBD guidance is not only addressed to states, but also to other actors. And the former and special rapporteur on Indigenous people's rights, for instance, has time and again built upon CBD guidance to clarify the responsibility of private companies to respect Indigenous people's rights in the context, for instance, of extractive activities. And there remains work to be done to clarify other non-state actors' responsibility to respect Indigenous people's rights, including conservation NGOs and bilateral financial donors and international financial institutions. But there's certainly been a plethora of work under the CBD that can help in that respect. And so this is just to show very quickly how the CBD guidelines, Aquacon guidelines, provide really key elements to understand environmental impact assessments in this context, not just as a technocratic approach to identifying potential environmental negative impacts, but really also looking at the viewpoint and the worldviews of Indigenous peoples and their appreciation both of negative impacts, but also of potential benefits that may arise from certain proposed activities. They have to do with a whole various dimensions of their lives, which many have, international human rights dimensions, but also really integrating their perspectives in terms of beliefs and languages, traditional tenure and uses, and transgenerational aspects. So a whole engagement with Indigenous worldviews and approaches that can support that more systematic approach to understanding the interactions between our choices related to biodiversity conservation and sustainable use and human rights. And interesting enough, another set of guidelines that are more recent from 2016, I think from the CBD provide both a picture of how governments are still divided in accepting and using in a consistent way international human rights law language under the convention. And so we can see here in the title of the guidelines how the expression free, prior, informed consent is not accepted as the only term of reference under the convention. And yet, once we read the guidelines, we find really important elements of understanding this process of consultation that goes beyond, I think, in some ways, the guidelines that we may have available or that are helpful complement to what we know from international human rights law, and particularly the emphasis on seeing consultation and consent as an ongoing process of partnership building, as opposed to a kind of a one-off green light kind of approach is really crucial to, as I said, moving beyond the use of the safeguards in, I think, in an unhelpful way towards a more transformative approach that recognizes the contributions of Indigenous peoples, that seeks to preserve the conditions for those contributions to continue, and for that mutual learning and collaboration around uses of biodiversity, sustainable uses and conservation. And we see the same approach, the same guidance also coloring the understanding of fair and equitable benefit sharing. So once again, trying to move away from what is the usual understanding, which is more transactional in a way, to one where we try and build a new kind of collaboration based on mutual understanding and learning with Indigenous peoples and local communities. And so in a way, what I'm trying to say, and I begin to discuss with you today, is that for how much maybe the engagement with international human rights standards may not be crystal clear under the convention, we have this development of guidelines will really come from the deeper understanding of how environmental governance works and how decisions on biodiversity are made. And we have indications about how we can move away from a damage control approach towards a more collaborative approach to identifying and co-developing solutions with different sectors of society. And this is the kind of transformative change that already the draft post-2020 global biodiversity framework is calling for. A more whole of society approach, whole of government approach, really trying to find truly collaborative and I think learning-based ways that are respectful and actually learn from different worldviews to really make the change that we haven't been able to achieve so far. And that I think has important legal implications that remain to be fully, I think, explored. One is about how we can think about impact assessment in ways that are open to that true engagement and partnership building beyond maybe a preset approach to development options. Also, I think it really shows the importance of strategic environmental assessments, which can allow to step away from the project level and really look at broader issues that may have to do with climate change impacts, that may have to do with historical inequalities that maybe Indigenous peoples and other communities have faced, and how all these are elements that then play out, but are easily fall through the cracks of more project-specific impact assessments. And of course, there's a big question around, both in biodiversity, but also in international human rights law, around consent and when or not that can be given and when it can be withheld. And I think it is really important to understand the whole of the interactions between international human rights law, what human rights are at stake, what are the obligations of states to really ensure that the consent process is adequate from an international law perspective, to really allow Indigenous peoples to have their rights respected and be at the same table in making these decisions with others on conservation and sustainable use. And I think the whole global emergency on human rights defenders, which is very much in the greatest numbers are about defenders of lands and terrestrial biodiversity, just shows how dangerous standing up for biodiversity is, and how these matters of decisions can become, can both show the shortcomings of governments, the personal risks, and in fact, actual killings and harassments and incredible, I think, human rights violations. So while we have this aspiration for transformational change, we also have to think about the very minimum standards that are necessary for this exchange to be safe. There remains various questions around who beyond Indigenous peoples are human rights holders in the context of those discussions, and under the CBD, we have attempted to define or further the understanding of local communities. We have, of course, other instruments that have been adopted under FAO that speak to the same understanding of other communities beyond those self-identified as Indigenous, that have that close relationship with nature and who have human rights who may be at stake when we take decisions on biodiversity. And so this is just to call to the attention of participants around other international human rights instruments, such as the recent UN Declaration on the Rights of Peasants, that provide further elements to understand which aspects and rights of certain communities might come to play when we think about biodiversity conservation and sustainable use. And John Knox himself in the UN Framework Principles has some interesting reflections around the other communities for whom we should put in place the same safeguards or similar safeguards that we saw for Indigenous peoples, looking at special dependency from ecosystem services and also questions related to discrimination. Now, what I want to do in a much faster way is also think about other relevant international human rights that come have come to the surface, I think, in the CBD, but not yet to the same extent of sophistication that we have in relation to Indigenous peoples' rights and other local communities' human rights. So I think it's been really interesting and fascinating to see how the CBD and WHO have collaborated in fully mapping the relationships between biodiversity and human health, and how those relationships affect other environmental challenges we face, from air quality to climate change. And I think based on that understanding of the factual connections, we already have some movement, both in CBD decisions, but also on the side of the WHO Assembly, to really think through how we need to think more systematically about the impacts of our biodiversity decisions on health, and on the other hand, the impacts of our decision on human health that may negatively affect biodiversity. And through all of that, which have also implications for our approaches, say, to climate change. And all of that has human rights implication. The human right to health has been mentioned in CBD decisions, but I think as I was saying, the potential of it to clarify international obligations and to bring communities together, communities of practice together, might not be fully realized yet. So this is one area where I think we have a lot of material for us to think about, but not yet as much clarity, and not yet necessarily maybe a full contribution of the CBD to the protection of the human right to health for all of us through its work.
Elisa, you have around 5 minutes.
Perfect, thank you. And I think a similar argument can be made around women's human rights and biodiversity. On the human rights side, the Committee on the Elimination of Discrimination Against Women has done quite a bit of work, which in fact, in some ways resembles those 3 safeguards we've seen for Indigenous people's rights in terms of the importance of impact assessments, consent, and fair and equitable benefit sharing, to make sure the rural women are not left out or negatively affected by our decisions in agriculture, water, forestry, fisheries, etc. And these are things that, again, on which the CBD can contribute, and all that plethora of guidance that we've seen recognized as relevant from an Indigenous people's perspective could also be maybe clarified with regards to women's rights. The CBD has made progress looking into gender equality, and we have a gender action plan. And I think one argument I've explored is how, while the action plan is really framed in terms of possible action for state parties, once we read the CBD in light of relevant international human rights law obligations on gender equality, and so for those CBD parties that are also party to the Convention on the Elimination of Discrimination Against Women, then some of these actions are actually legally binding obligation in as far as they are, they overlap with those international obligations under international human rights law. And so once again, it's important to engage in this thinking to really understand what's the minimum conduct that is required from states in implementing, for instance, the CBD Gender Action Plan, and what else we can expect in that context, but also what, as human rights lawyers and experts, we can benefit in looking at the CBD work. And so there's many practical steps that have been identified under CBD COP decisions that, again, provide very practical approaches to advance the consideration of women's rights in the particular decision-making related to biodiversity. And so that learning from practice that I think is often captured in CBD COP decisions is available there for, again, human rights constituencies and biodiversity constituencies to work together towards shared goals. I won't go into too much detail here, but just to say that there's also a lot of relevant work under the CBD that has brought together the ecosystem approach, in some ways a human rights-based approach without calling it as such, in the context of CBD decisions on climate change. And so providing approaches, specific approaches to an ecosystem-based approach to climate adaptation and mitigation. There's really quite a lot of concerns that have to do with tenure, with consent, with livelihoods and human health that reflects and creates entry points for the consideration of human rights. And so what I would like to say here is that we're not starting from scratch in looking at how we integrate human rights into climate change, how we bring together also the ecosystem approach. That CBD guidance has done quite a lot already to provide directions and capture lessons learned And once again, we need to read that from the perspective of individual states' obligations under international human rights law to fully maybe and better understand what a recommended action might actually be really important and potentially minimum conduct from an international human rights law perspective. And to conclude in a minute, I hope, Patrick, I just want to say that for how much there's a lot of progress that needs to be fully understood under the convention in relation to human rights, there's also areas where we urgently need more work. One of these areas is certainly the link between marine biodiversity and human rights. If you see both on the, I think, international human rights law, the engagement with the CBD has really been on terrestrial issues, but we really miss an understanding of the importance of marine biodiversity for human rights. And for instance, in his most recent report, the UN Special Rapporteur on Human Rights and the Environment, David Boyd, recommended considering human rights in the context of the UN negotiations on marine biodiversity of areas beyond national jurisdiction. But I think that one of the challenges there is that the science, the understanding of marine ecosystems in the deep sea is not fully there. And with that, we have this important gap in understanding then what functions these ecosystems serve and who may be affected in their human rights if we fail to effectively conserve and use sustainably marine biodiversity of areas beyond national jurisdiction. But that, while the science advances, that shouldn't prevent us from advancing our understanding of relevant human rights. Surely procedural human rights are very relevant here, and so we shouldn't see decisions related to the marine environment as separate from all that we've discussed before about an ecosystem approach and a human rights-based approach. And I think here just to mention that some of the challenges that have been experienced more recently in relation to COVID-19 and barriers to participation have been very much present also in decisions related to blue economy and marine protected areas, and maybe with that added challenge of the marine lagging behind. And the second area of gap, which is a bit linked, is that of children's human rights and biodiversity. John Knox had done quite a bit of work to clarify the relevance and the fact that children might be the most affected by biodiversity loss because of their ongoing development and the fact that they live longer with the implications of biodiversity loss. And he has identified few key legal implications for us to reflect on. The importance from a procedural perspective to include children's views in our decisions on biodiversity and climate change, in the fact that in all actions concerning children, and I think this should be read, in all actions concerning biodiversity, which may affect children, then the best interest of the child should be a primary consideration. Now, again, what that means specifically for biodiversity and particularly marine biodiversity, I think remains to be worked out. And at the moment, we have 3 international processes where it's important to engage to that perspective. So the UN Committee on the Rights of the Child is starting work on a new general comment to clarify children's rights to the environment. The UN itself, the UN system, has committed to promote children's rights in relation to a healthy environment. And of course, maybe there are pushes, I think, under the CBD and the post-2020 biodiversity global framework to think about intergenerational equity, maybe in harder legal terms, and children's rights might be a way to advance the conversation. So I'll stop there, and thank you so much for bearing with me going a bit over time.
Thank you very much, Elisa. This was really an insightful presentation, a lot of material, very interesting, and personally I learned a lot. I will not say much more because I think we have a lot of questions in the chat box already. But I also want to say to the participants, if you still have more questions, feel free to type them in. You can also upvote questions from other participants that you'd like Elisa to answer. All right, so going with the first question from Anupam Anand. They ask, in conservation and development organizations, human rights are primarily covered through safeguard policies. Do you think the human rights approach should go beyond safeguards? Maybe you can just start with that, and I will.
Yeah, no, that's an excellent question, and thank you so much for raising it. I think safeguards is the bare minimum we need to do to prevent negative impacts on human rights. But of course, human rights obligations are understood as obligations to prevent, protect, and fulfill. And I think, again, thinking about transformational change, it is important for states and others to think about obligations to fulfill human rights and to really look at the integration of human rights in biodiversity decision-making as a proactive consideration that allows us to be more precautionary, that allows us to think more, I think, creatively about the challenges we're looking at, and not just prevent damage, as I was saying, but really finding genuine approaches for co-benefits across environmental challenges and across human rights challenges.
Thank you. Next, we have a question from Lena Avelan, who asks, what do you see as the role of the human rights approach in global treaties and law other than biodiversity? I know you've touched upon this a bit, maybe you can elaborate. And is there a particular importance to have human rights-based approaches in biodiversity law compared to having human rights approaches, for example, in trade treaties or global treaties of very specific activities like fishing, mining, telecommunications, or IT? Please.
Another excellent question, and I think the approach should be the same. I mean, states need to implement all their international obligations, and so those that arise from the CBD, from international human rights treaties, and other treaties that they're party to. So ideally, and this is what I think in many ways CBD COP decisions often help to, they need to arrive at coherent interpretation of multiple obligations. And then they should work towards implementing the coherent understanding of their biodiversity obligations, human rights, and climate change ones in any other action they take. And so, for instance, in trade agreements and bilateral investment agreements, that understanding that biodiversity conservation and sustainable use, ecosystem approaches to climate change are interdependent from the protection of human rights needs to be captured and to shape and limit the obligations that are then created under international trade agreements and investment agreements. And again, there's a potential for those agreements to actively contribute to biodiversity conservation and sustainable use and human rights protection. And some countries and regional groups try to use them to that end. But again, that may not necessarily, I don't think we have yet come to a practice where the full potential of that coherent interpretation has been achieved. And it's always important also to have those safeguards in place, because unfortunately, for how much we may try, there may still be negative tensions with maybe trade and investment. And so both the positive transformative side and the minimum guarantees through safeguards need to be embedded as part of that coherent understanding of state obligations from multiple sources.
Wonderful. Next up, we have a very specific question from Ioannis Agapakis, who says, the component of equitable governance in area-based conservation can take many forms in accordance with national legislation. What would be some of the legal avenues of making conservation funding conditional on a truly equitable governance line, in line with international regional human rights instruments and UNDRIP, the Declaration on the Rights of Indigenous Peoples? And only if you know, of course, does UNDP use those instruments and refer to them when funding national conservation projects?
Yeah, now this is another great question, and I think it raises the point that when we think about governance and conservation, we can't look at that in isolation from the importance of international finance and international cooperation in those efforts. And so the question there is, on the one hand, we see that, well, UNDP and other multilateral bodies that provide funding or support or capacity building to conservation have realized that they need to step up their work to make sure that using human rights approaches can be one way in which to ensure equitable governance of conservation. This is also true for conservation organizations benefiting from that international funding. And again, I think both the UN Special Rapporteur on Human Rights and the Environment and the Special Rapporteur on Indigenous Peoples' Rights have both contributed to create as much guidance as possible to support donors, international organizations and NGOs in this connection. But the CBD itself has also contributed developing COP decisions on biodiversity safeguards for financing. And I think so in a way, again, you know, it's really, there's two steps there. One, fully understanding how human rights standards apply to conservation, and then all the entry points. And a key entry point is finance and who provides finance, in addition to those that take decisions about conservation measures and those that implement them. And I think maybe a third point that has been recently raised also by Professor David Boyd and Special Rapporteur is that we need human rights training also for enforcement officers involved in conservation activities. So it definitely starts from funding, and funding bodies can really shape a sector through their own funding conditions. So when we'll get to a stage where we see international conservation funding bodies really setting the example and fully integrating human rights standards into their approaches to conservation, that might become an important driver for change at different levels. But as far as I understand, we're not quite there yet.
Thanks, Elisa. This is really helpful to understand how it plays out in real life, really, beyond just the policy context. Next up, we have Christine van Douden, who asks or comments, human rights are mostly protecting individual rights, which is sometimes in contrast to collective rights practiced by Indigenous communities, especially in relation to territorial laws. Should or could this be addressed in the CBD?
So I think this is a really big question also for international human rights law and scholars. I think on the one hand, we have moved away from that purely individualistic approach to human rights protection, but there remain still important areas where maybe we don't have enough understanding of, for instance, collective rights from the viewpoint and worldviews of Indigenous peoples to be able to really integrate them and protect them in the national and perhaps international legal responses. But I think there are other cases, so other communities might have collective approaches that human rights need to protect. But I think also if we think about everyone's right to health, children's rights, women's rights, we also have collective dimensions there. So I think that on the one hand, maybe it is no longer true that human rights are mostly protecting individuals, but that said, I think there's still work to be done for them to be fully aligned with more collective interest. And the case of the collective rights of Indigenous peoples is a really paradigmatic one, where we have, I think, additional gaps to be filled in terms of intercultural understanding, but there may be other examples. And I think, well, the CBD could be a really good forum, but not the only forum where we can explore these questions. And I think, to my mind, for this and maybe other question, what I find fundamental is that the CBD shouldn't be the only forum, but it should be part of a network of international fora where we share the understanding, where we share learning. So that could be with WHO on collective approaches to protecting the human right to health. That can be with the UN Permanent Forum on collective rights of Indigenous peoples, and say with the Committee on the Protection of Women Against Discrimination, for instance. So I think thinking about more learning processes that connect the CBD with other relevant fora will be an important to advancing this question.
Mm-hmm. Thank you. We have a question from Maria Ovalle that connects quite nicely to this one. She says, biodiversity is also in cities. How do you see the relationship between human rights and urban citizens that are not Indigenous peoples and local communities?
Yeah, no, that's a great question. And again, it was interesting. Just recently, I was discussing with some colleagues the CEDAW guidance on rural women's rights. And for instance, saying, well, what about urban women? So I think there are many aspects in which human rights holders, both as groups, as in individuals, we tend to think about the relationship with biodiversity in a rural context. And the reality is that maybe the relationship in the urban context might be lagging behind in our understanding. I think the lens, for instance, of the human right to health may be more easily adapted to an urban context. And some of the evidence from that CBD WHO state-of-the-art report really shows how individuals in cities benefit in such distinct ways, you know, a recovery time from surgery, mental health benefits from exposure to biodiverse areas. But there are also urban collectives, collective groups who may not fit into Indigenous peoples or potentially local communities that may receive a collective response. So that's an area for sure where we need to do more advance understanding.
Thanks. Ina Tesno von Wisoki asked or comments, thank you for the interesting presentation. To what extent are future generations included as human rights holders in existing international law?
So here I really take the cue from Professor John Knox. In his report on the rights of the child to a healthy environment, he basically said, future generations are here, are born every day. We don't need to think about future generation decades from now. And so in a way, we do have legally binding international law on future generation in as far as the rights, human rights of children are concerned. And it's true that also in discussions with the former Special Rapporteur on Toxics, for instance, his view was that the Convention on the Rights of the Child might be the least utilized and most promising international human rights treaty that can contribute to biodiversity conservation and sustainable use, and really help, I think, decision makers and others to take that longer term dimension in thinking about decisions on biodiversity conservation and sustainable use, because children have legal entitlements to that protection on a longer time scale and with consideration to the right to development, to physical and mental development. And so that brings us into decades in terms of time perspective, as opposed to maybe the next 5 years, which might be usual a government time perspective in terms of other socioeconomic balancing they may do in relation to conservation and sustainable use. So that's where, for instance, the point, one of the pillars of international the international protection of children's rights, the best interest of the children should be a primary consideration, can be a huge game changer in decisions on biodiversity, because it really asks decision makers to think in decades and not to think about impacts in the next 5 years. And that might make more sense also from an ecosystem perspective.
Thanks, Elisa. We're almost at a close because we have to close on the hour sharply. We have another final question, perhaps from Howard van Asselt. In the area of climate change, strategic human rights-based litigation is a very important trend. Do you expect that such litigation will assume an increasing importance in the context of biodiversity protection as well? And do you think that would be a welcome development?
Yeah, no, that's another great question. And I've been discussing this with colleagues in climate change and also in biodiversity. But I think for what it shows at the moment is that the current trend is very focused on climate change, even if there are very obvious interdependency between climate change and biodiversity conservation and sustainable use. And I think often existing climate change litigation would have benefits for biodiversity conservation and sustainable use too. So I think it might well be, and I think there are scientific and legal reasons why that litigation could and should expand also to biodiversity. There is, I think, an element of capacity building of the lawyers and the litigants in this area to engage with international biodiversity law. And I think even consider the international biodiversity law has developed enough to bring an additional legal edge to that litigation. There's also a question of whether judges, would maybe need to be more exposed and understanding better biodiversity science and law to engage in that. And I think if on the one hand, I think if there is gonna be more climate change litigation and human rights litigation, I hope that it will be done in a way that is inclusive also of biodiversity law and concerns. As to whether that would be a welcome development, I think that's a tricky question, and at least in scholarship, the question is open as to whether litigation can really be the best push for governments and other state actors to live up to their international obligations. But there are situations where it seems like other ways may not work, and so it's important to have that avenue open. And certainly from a human rights perspective, the idea of access to justice and effective remedies is essential. And so I think a future, near future biodiversity, climate, and human rights litigation might be one helpful way, but we need others for pushing for that transformative change that we need, and the more interconnected thinking around the science and the law on biodiversity, climate change, and human rights.
Thank you, Lisa. This brings our webinar to a close, and I just want to say a very huge thank you to the organizers, both from UNEP and the University of Eastern Finland, And of course, also a big thank you to all of you who joined us today. Thank you for very engaging questions. I know there were more in the chat than we could answer, but we'll take them with us, and hopefully this will allow both Elisa and me to reflect on our ongoing research and work. If you haven't yet, please register for our next webinar next Tuesday, where we'll be joined by Bala Pisupati from UNEP, who will share his insights on the regulation of emerging technologies under the CBD. Thank you very much. It's been a great session. And again, big thank you to you, Elisa.
Thank you so much.
Bye.
Bye.